And ma'am, your name, please.
So bad.
Your Crystal Bass. Okay, you've got two cases, Ms. Bass. In 25 CO 1809 and 1810. Assault on hospital personnel and hospital property. Each of these cases on or about, well, one was alleging on or about November 8th, 2025, that event. And the other is on or about October 14th, 2025. And then the indictment, God bless you, goes on to allege that in 2019, you were convicted out of Hardin County District Court for attempted aggravated assault. So these two charges on assault on hospital personnel are third-degree felonies. If all of this was found true in these indictments, your punishment range is a second-degree felony. You're looking at no less than 2, no more than 20 years confinement in prison. Probation is not an option because you have, according to the indictment, been previously convicted of a felony, which eliminates any probation. Let me look at this. And she had earlier been evaluated by Dr. Ed Griffon for the issue of competency to stand trial. And Dr. Griffon, in a letter dated June 26th of this year, a week or so ago, deemed the defendant to be competent to stand trial. What are we doing?
Judge, I just wanted to go over her options with her. She has a current offer from Tommy Coleman, the new prosecutor in her case. That is only good for today. He's offering a plea for 2 years, running concurrently on each case. After today, that offer will go up to 5 years. As you explained to her, you do have 2 pending third-degree felonies. You understand that, right?
You have to speak out so she.
And then with that prior that you have on the record, you understand that you wouldn't be eligible for any kind of probation out of trial. Okay, and with that prior that you have on your record as well, that would also enhance you to a higher punishment range. So instead of your punishment range at trial being the third-degree felony range of 2 to 10, it would enhance to 2 to 20. You understand that? You understand that you have a current offer on the table for 2 years TDC, and then you have 140 days credit.
Yes, ma'am.
Okay, and are you wanting to accept that offer, or do you want to set your face for trial?
I'll accept the offer.
Okay,
Okay, is this a plea in each case?
yes.
To run concurrently? Right? That's your understanding?
Is that what you want to do? You can set your case for trial.
Write it up.
I just need to make sure that you understand all of your options.
Write it up. That's good today.
Okay.
Thank you. All right, thank you. We get to this here. 2 cases are now called 25 CR 1809 1810. The state of Texas versus Crystal Bass. You are Crystal Bass, correct?
Yes.
And you are here with your attorney, Ms. Minaldi, and the state's attorney. Does the defendant waive formal readings of the indictments and arraignments? Can we proceed in summary?
Yes, Judge.
First of all, again, for the record, Dr. Ed Rapon analyzed the defendant for competency, and in a report dated June 26th of 2026, the court, Dr. Rapon deemed that his analysis showed the defendant to be competent to proceed to a resolution of her legal issues at this time. And that will be part of the record and sealed in each of these 2 cases. In summary, each of these cases similarly allege the third-degree felonies of assault on hospital personnel in 25 CR 1809. The defendant is alleged to have caused bodily injury to a nurse employed at the Fannin Behavioral Facility. And in 25 CR 1810, the defendant is alleged to have caused bodily injury to a doctor employed at St. Elizabeth Hospital who was treating the defendant. In each of these cases, these are third-degree felonies. The defendant has a prior conviction, but we are not moving on that, correct?
That's correct, Judge, just proceeding from paragraph 1.
These are third-degree felonies. In each case, the defendant faces, if convicted, a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here, ma'am?
Yes,
Agreements have been reached where you will be pleading guilty, sentenced to 2 years in prison in each of these cases to run concurrent. Yes, Judge. Is that your understanding of the plan?
no, I was wanting to, right, does that mean I get 2 years for each case?
That's right. That's what I just said.
Okay,
That's what we're going to do.
is that about 4?
That's why I do this.
2.
Oh, it's
Yeah,
just-
that's why I do this. They run together
Okay,
at the same time.
yes, sir.
Okay. People kind of get confused about that word. It's a big word and it's concurrently, but it means the same time. And consecutively means 2.
Yeah,
But these are 2 together.
yeah,
That's your plan. If I follow this agreement in each case, you have no right of appeal of your cases. Do you understand?
yes,
How do you plead in each of these cases? Guilty or not guilty?
not guilty,
You've been pleaded not guilty. You're pleading not guilty or guilty?
not guilty,
Oh, you're not guilty of these crimes?
no,
Oh, I thought this was a plea.
Judge, it was supposed to be.
Okay, we're going to trial.
You understand with the plea that you have to plead guilty freely and voluntarily.
oh, I didn't do this.
Okay.
That's fine.
Are y'all kidding me?
No.
Okay, well, this is, okay, this is set for trial. It's going to be trial at another time. And that's weird. Okay. Forget that. And here's you have to understand also, this alleges that you have been convicted before and out of Hardin County for attempted aggravated assault in 2019. If you're found guilty in these cases, you will not be eligible for probation. Probation is not eligible. So you are looking at, if convicted, and you're not going to get probation because of this, if this is true, you are looking, because of the prior conviction, if convicted, you are looking at 20 years in prison, up to 20 years in prison on each case, which would run separately, 20 and 20. Okay, just so you know.
And you understand that today the offer was for 2 years, but after today, that's not an offer.
Yeah,
So you want to reject the offer for 2 years.
yes,
You're making that decision thoughtfully and
Yeah.
upon discussions with your attorney.
yes.
Okay, that's what you will get. Thank you. We'll set it for trial. What else?
Christopher Burkett, Judge.